benefit division at Oswald Companies. Kurt, take it away.
Thanks, Rick, and hello, everybody. This afternoon, I'm going to be specifically addressing the COVID-19 impact on your employee health insurance plan in general terms regarding coverages and eligibility as they relate both to the recent federal and state of Ohio requirements. There's a lot of different carriers in the marketplace and different funding arrangements. You may be self-funded, you may be fully insured. Some of the carriers will address these requirements in a more liberal fashion, so I recommend that you reach out to your broker advisor to confirm how your particular plan is impacted. But first, for the Families First Coronavirus Response Act, which is the federal requirement. This has mostly to do with coverages of your plan, your employee coverage. And there's really two areas. One is testing of the virus, and the other is treatment of the virus. In terms of the testing and the test-related visits, they are covered. And what the mandate says is that you can have no member cost share in the testing or the related test-related visits. And this is either in or out of network, your provider network, doctors and your places of service. The related visits include office visits, urgent care, emergency room visits, that type of thing. The office visits also have two parts. One is you walk in and you see your doctor in person, but because of all the social distancing and that type of thing, they're allowing telehealth visits. Now, the telehealth visits are different than telemedicine in this regard, in that the telehealth is you pick up the phone and you call your primary care doctor and you have a conversation with them. That is a covered benefit, which typically is not. The telemedicine, on the other hand, is an add-on benefit to your health insurance plan that you may or may not have, where a plan member can pick up the phone, maybe they have a sick child, they talk to a doctor for minor diagnostic and medications can be filled in that regard. So they're different, but they both are being covered at this point. Telemedicine is not necessarily required to have a no employee member cost share. In terms of the treatment, I don't know of any plans that don't cover the treatment. However, it's not mandated that the terms of the member has to be sharing the cost. So the treatment will be covered, but the employee would be covered subject to the deductible, the co-insurance, copay, out-of-pocket, etc. You can go to the next slide, please. We're moving on to the Ohio requirements. This was effective March 20th and expires at the expiration of the state of emergency that was declared by Governor DeWine on March 9th. And this applies to carriers and insurance plans that are fully insured, they're self-funded, and stop-loss insurance policies. In normal times, typically self-insured and stop-loss policies would not be guided under state mandate, but in this case, they are. Go to the next page, please. So when we talk about the state requirements, really focusing on eligibility of the employees. And there's two categories of employees that we're going to talk about. Number one, a term that we haven't really heard a whole lot about in the health insurance marketplace, a furloughed employee. That is where employees are not working the required number of hours of work to be covered, or not working at all, but have every intention by the employer to return to work. This allows coverage for any plan hourly requirements. So there is no actively at work provision. During this time, they would be covered as if they were active. It also prohibits insurers from adjusting premium by losing those employees off the plan. They cannot re-rate your premium mid-year. And also one other point on the furloughed employees, many plan documents and employee handbooks don't define that as a qualified employee. I would suggest again that you reach out to your broker advisor to be sure that that does appear in your employee handbook or your plan document going forward. Layoff is the other category where you're actually terminating an employee. Now, typically that would be a COBRA event or a continuation event, depending on the size of your group. But in this period, the laid off employee would be treated also as any other employee who is working the required number of hours to be a full-time, qualified as an eligible plan member. Once this period ends, however, any laid off or terminated employee would have to go on to COBRA, and would be responsible for the payment of that premium unless you as an employer choose to subsidize that premium. If you could go to the next slide, please. Two other requirements. One is they're extending the grace period. Plan premium typically has a 30-day grace period. They're extending that 30 days. So total grace period for premium payment will be 60 days, again, during this period. The special enrollment is in there. Inevitably, you may have terminated employees. That would be deemed as a qualifying event under the special enrollment provisions. Regardless of what coverage they get after your coverage, there will be no, they'll get immediate coverage without any waiting periods. One quick mention, Oswald does have a unit that addresses individual coverage for displaced employees that are either in transition to get new group coverage or looking to get individual coverage in the marketplace. We can help you with that. So just something to keep in mind. And the last point I want to make that all of these requirements do not apply to your group dental, vision, life, or disability lines of coverage. And so with that, I'm going to turn it over to Todd, I believe.
Yeah, thanks, Kurt. You can go to the next slide, Ann. Thanks. Yeah, I want to focus a lot of the time on the business continuity planning that Jim Hedrick's going to talk about. But the three major questions from an insurance standpoint that we're getting at Oswald is business interruption. How is this? Do I have coverage or not? Is this going to trigger that coverage? The FMLA and the new legislation that's going on that Kurt just spoke about. Thanks, Kurt, for going over that. And third, is there anything from a premium payment standpoint similar to what's going on with the benefit side that we could hold off on payments because of these times? So number one, business interruption. Each policy, I'll start by saying each policy is going to have different language, different exclusions. So you should definitely discuss with your broker, advisor, legal counsel. However, the common trigger for business interruption or contingent business interruption is property damage, meaning a covered cause of loss, fire, wind, hail, etc., must cause direct physical loss of or damage to the property at the described premise in your policy, so at your location. As we can tell, a lot of what's going on now is not triggering that property damage at your facility. So the insurance is not commonly triggered. And as I said at the beginning, everybody's going to have different coverages, everybody's going to have different language, and they might have some throw-in coverages, environmental liability policy that could trigger or could provide a little bit of coverage. So I definitely want to advise you to talk to your broker. But from a broad global standpoint, there is a lot going on as far as the trigger of the property damage, which would then trigger the business interruption coverage. So secondly, civil authority is something that a lot of folks are talking about that are in policies. So in this instance where the government is forcing a shutdown or forcing limited people coming into your work and therefore a business loss is occurring, that is also triggered by the same property damage coverage in most cases. So unfortunately, in most cases, the business interruption coverage is not considered to be a covered cause of loss, or it's not covered at this time. Now there's a lot of things being discussed, as I think a lot of you are aware, between the lawmakers and the insurance industry. So There's going to be a lot of conversation around this. We're telling people going into the next bullet point, should I still submit a claim? We think at this time we are telling our clients, yes, go ahead, submit a claim as you normally would. Each claim from COVID-19 are very fact-specific and dependent on your claim scenario and the terms in your insurance policy. So there's going to be a lot of continued talk about this, but go on as you would. There's going to be continuous updates and things going on around this subject. But please talk to your broker, talk to your advisor, make sure that you're keeping good documentation of how your business is being affected. Because if there is a time where things change and this business interruption coverage is considered to be covered, you want to make sure you have all the documentation ready and prepared in order to make that claim. Oswald has a resource page that we've put out that I'll give the folks at Manufacturing Works to make sure everybody on the call has access to, where you can go to our website and find it. But it has a lot of different topics, and one in particular on how to make sure that that business interruption records are kept properly and how to prepare to make that claim. The emerging things that I want to talk about, the employment practices and directors and officers, as these major changes are coming and people are making a lot of, maybe laying off some people, working from home, a lot of different things that we're not used to. There's a lot of new risks, inherent risks that are going to be involved with those employment practices and D&O claims. So make sure, again, you talk to your advisors, talk to your legal counsel about any changes that you're going to make, because this can lead to definitely some claim activity in that aspect. Directors and officers as well. They're making important decisions. Do we stay open or not? Do we have the right safety protocols in place? There's a tremendous amount of impact that this could have, not just from your business, but from business partners, your clients. And even though you might feel it's the right decision to close down, if somebody is expecting you to stay open and they need your product in order to make and sell their product, then that could bring on some claims from the directors and officers standpoint. And thirdly, the premium payment options, as was mandated on the health insurance side, for a 60-day deferment, we'll call it that. On the property and casualty side, there has been no mandate to do so. However, each carrier has been providing different options to either delay or defer those payments, some up to the same 60 days, but each situation is different. Each carrier is having different options. So again, talk to your broker advisor about what those options are for you. And hopefully, if you have any other questions after this, we'll be glad to answer those. But I'll turn it over to Jim.
Thanks. Can you hear me, Ann?
Yes, we can hear you, Jim. Thanks.
Awesome. Thanks. So if you can go to the first slide. And I have animation in these, and I apologize for that. I didn't realize I wouldn't be handling my own slides, but go ahead and hit that. There you go. So I want to start with, I've done pandemic planning for about 15 years, and I've spent time in Asia doing this as well as spoken at global conferences. So I've studied this subject quite a bit. And what I want to do is I want to start out with exactly where are we now? Because I think this is super important to understand. If you see the different highlighted arrows I have going up there, the yellow one is United States, and the other two are Spain and Italy. We are in the exact same trajectory as Spain and Italy. I expect the country will come in and out of waves as we go through this over time. But, we need to recognize that the entire world, the entire country, all the different states and within the states will not be going through the pandemic at the exact same time. That's super, super important to recognize. So go ahead and hit the next slide, Ann. Okay, and I've put some waves in here. As I mentioned, I've studied this quite a bit, and I've got some very irregular waves on this particular slide, and it represents that a pandemic is not going to be one wave. The waves are going to look different. Once we rolled into this one, we roll back out, depending on how we treat it in our different states, our different localities, or in different countries, will make those waves look different or similar. Right now, I believe that what we're doing is, at least in Ohio, we are locking things down to a certain degree to limit the spread. But what's happening is the spread is happening within households and families now. When we bring people back out in the public, it'll start happening in the public again. So, it's kind of like a pick your poison kind of situation. But historically, pandemics have lasted about 18 months. And I want you to think about those waves, because what you're learning and what you're doing today and what you have done to date, take good note of it, because you very well may have to go through those stages again. Okay, next, Anne. There's a lot. Oh, perfect. Thank you. You took the animation out of this one. Awesome. Anyhow, I want to take a look inside a wave, to give you an idea of what we've gone through and how we can plan. As with any business continuity planning effort, it's best to do it by stage of an event. With a pandemic, there's stages within stages of an event. So if you start there on the left, when we started ramping up, we started really paying attention when we started seeing some of this stuff overseas. I think when it first popped up, we thought it was an anomaly overseas, and then started heating up a little bit. So we started paying more attention. Then we thought, well, hey, this thing could be real, so let's start looking at what we feel is critical within our organizations. A business continuity program, one of the foundations of it is a true understanding and organizational agreement on what our organization critical functions are and which ones must be continued at the time of an event and which ones need to be restored and in what order. So we took that time, and that's not as easy said as done, or done as said. So then we started building some points. I think, hey, it's getting pretty real. We sensed DeWine's stair-stepping towards something. So let's start testing some plans and maybe even implement some plans. In an office environment or an ability where you have the ability to work remotely, you've got this opportunity to test those kind of things. So that's what we did. So when we get into this closed period right now, that could have been triggered in many different ways. It could have been something you determined to do locally yourself, or it could be something that was dictated, to you by the state. So we've gone into this closed period. And this is really, really super interesting, because I'm not sure exactly what the back part of this closed period looks like. As people continue to struggle, businesses, financially, the backside of this could change quite a bit. But I want to let you know that I would already start looking at coming out of this, planning for that next stage to where it's really bad, but people are starting to come out of their holes and their hibernation a little bit. But when they do come out, it's still going to be pretty bad out there. So we need to expect and prepare for those conditions. What's it going to be? As we come back out, I've got identified critical functions again. And the reason I do that is based on the conditions that will exist during this closed period, you may have different business priorities when you come out of the backside of this. You may have different business partners. You may have different customers, and when you're going through this identifying critical folks, identify your critical inbound, raw materials and supplies, but also your customers, because it's an entire supply chain. You start planning for de-escalating your entire plans, and do it by step. You can't just throw the switch to put everything back to normal immediately. We're going to de-escalate, and it's going to take some time to get back to what's kind of a new normal. And by that new normal, I'm putting a very positive spin on that and saying that we're going to learn things as we go through this, that, we found better ways to do things, and we're going to, stick by them and keep them forever. So go ahead and jump to the next slide, Ann. I just want people to see the inside of the wave. So right here is a period I want to show you between pandemic waves. This is a tremendous opportunity for companies. Companies who plan through this, think it through, will have a competitive advantage on many organizations. So take those opportunities to look backwards, reset your plans, reset your triggers. If you looked at that zoom into the wave we have, each one of those vertical bars, I would consider those a planning stage. Look back at those, define them by what they meant to you, and build clear actions by each discipline of the organization. So in between those waves is a tremendous, tremendous opportunity. Okay, next slide, Ann. This will be my last one. What are some current actions you should be doing? Situational awareness is everything. Paying attention to what's on the other side of the world, how companies are reacting, governments are reacting. All of those are indications of what can happen here. You want to plan globally and act very, very locally. You need to make sure you're protecting your on-site employees. For the ones that are part of the essential businesses, if we bring people on site, let's do our best to maintain that social distancing, additional cleaning. There's a lot of restoration companies out there coming into a very deep clean of your organizations. Support remote workers. It's very odd. I think people are speaking more to the person who was in the next office to them now that we're remotely than they were when they were in the office. So continue to support people, keep their morale up, and keep working with them. In the event you have some employees that you have identified as not critical, and that's a bad term, so I'm putting on my air quotes here, you can't see. If we can find ways to redeploy them or send them to somewhere else where there might be a surge of activity, let's have an ability, a job bank, so to speak, to be able to do that. Once again, review your actions to date. Can't say that enough. Continual evaluation. This is not like a fire, tornado, hurricane. In those we've had plenty of times to have gone through them in the past and learned from them. But every day it seems like something is changing with this event. The new regulations that have come out that Kurt and Todd spoke about, those are all part of your business continuity efforts, because every decision you make has a potential positive outcome or a negative outcome or consequence. Then stay in communication with suppliers and customers. And like I said, there's no need to continue manufacturing if the customers who are buying those products are no longer open or not in a position to receive the product. So I will stop there. It's about as fast as I can run through those slides, and I would could talk for hours on the subject. So go ahead.
Thank you. Yeah, if there's any questions right now that anybody would like to put into the chat box, we would be happy to address these questions for you now. If you'd rather hold off until the end of the presentation, there will be time at the end to also ask questions of both Oswald and Weston Hurd. But if there are any questions now, we'll go ahead and give you a second to type. Okay. Well, let me go ahead and introduce our next presenter. Attorney Fred Bills, partner at Weston Hurd, is going to cover the legal aspects of business continuity in this coronavirus epidemic right now, or pandemic. So, Fred.
Thanks, Rick. Thanks for having us. One of the things our law firm was really focused on is how can we provide services to our clients that they need right now, where they're in an environment that has changed so drastically, so quickly. And part of that, especially for small businesses and manufacturers, is going to be what happens if you're not able to perform your obligations under a contract at this point due to either the coronavirus spread or due to the actions of Governor DeWine in shutting businesses down. Obviously, that leads to all sorts of different potential problems, shortage of manpower, whether or not you were deemed an essential business so that you could keep your doors open. All those things are going to play a significant role in whether or not your company is going to be able to fulfill its contractual obligations. And one of in contract law, the theme or term of art that we use in relationship to when is a party excused from its contract due to an unforeseeable circumstance occurring is called force majeure. Next slide, please, Anne. So force majeure is a term, it's out of French law, it means superior force. And it's supposed to anticipate when something beyond a party's control, such as an outbreak of war, a natural disaster, riots, strikes, insurrection, or acts of terror, when those things occur, if those cause a party not to be able to perform under its contract, then the party can be excused from the contract or from performing under the contract, excuse me. Traditionally, force majeure contracts have not included language that addresses epidemics or pandemics. Now, we have seen that change recently over the past 10 to 15 years with the SARS outbreak, the Ebola scare from a few years ago, that people who were writing contracts, attorneys who were writing contracts, were thinking about public health emergencies as a condition to include in force majeure clauses. But because this is contract law, the clause itself needs to be very specific as to the type of event that's going to excuse a party from performing under the contract. Next slide, please, Ed. So the ultimate question that your businesses are looking for today is whether or not, if your contract has a force majeure clause, whether or not it can excuse performance under the contract. It's going to depend significantly on the language that is in the contract itself. So if there's an express reference to epidemics or public health emergencies, then obviously the coronavirus and the spread of COVID-19 is going to be included. If there are catch-all provisions that are typically included where parties want to have a broad force majeure clause, then it's going to enumerate different examples of what it might be, and it will try to create conditions that will have that provision be broad. Oftentimes you'll see act of God as one of them. Next slide, please. Another condition that you need to be aware of in the force majeure clause is whether or not there are notice requirements. So many contracts require that any party who seeks to assert a force majeure as a basis for suspending performance promptly notice its counterparty. And failure to do so may result in waiver of that defense. Other conditions that you need to consider under a force majeure clause is whether or not it excuses performance or whether or not it just suspends the obligation to perform during the time period where the condition or the event that's causing non-performance exists. Next slide, please, Anne. With COVID-19, there's some other principles of law to consider. I think with the fact that the landscape has changed so significantly due to government action, there's a principle of law called frustration of contractual purpose. There's also a principle of law called impossibility of performance. And basically, that's when it's an affirmative defense that can be asserted for a claim against breach of contract, where even if the parties didn't include a force majeure clause in the contract, the party who's defending against breach can make the argument to the court that first, the conditions under which the parties executed the contract have changed so significantly that it makes performance impossible due to unforeseeable circumstances. Now, the unforeseeable part will be interesting to see how courts interpret that in the future. Obviously, we did see a significant spike in China and the drastic measures that the Chinese government took in enforcing quarantine and enforcing social distancing that has become a part of our normal life now. And it's arguable that the United States wasn't prepared for that, but that it was foreseeable. Ultimately, moving forward, it's going to be very important for businesses to include a force majeure clause in their contracts. I think there are important lessons that this event can teach all of us. And one is we need to have a very, very broad expectation of what things can cause us to not be able to perform under a contract and protect ourselves by having a force majeure contract or clause that's going to try and capture those provisions. Okay, that's all I have, Ann. Thank you.
Hello, everyone. This is Jonathan Good from Weston Hurd, and I'll be talking today on the new employment laws. Last week on March 19th, the emergency expanded FMLA law was passed, and it implemented an expansion of traditional FMLA for one category of people. And at the same time, in the same law, it also provided for emergency paid sick leave. So let's talk about the emergency expanded FMLA law. This expands traditional FMLA to include one specific group of people. By way of background, we all know that FMLA can be taken for eligible employees who have serious medical conditions or have to care for eligible family members for serious medical conditions. And those employees had to be employed for a certain amount of time and 1,250 hours. But this new law scraps the time requirements. Now, eligible employees have to work for 30 days. If an employee has worked for 30 days, they are eligible for FMLA and this new expanded portion. This new expanded portion allows an employee who's been employed for 30 days to take up to 12 weeks off to care for a son or daughter who is home from school or daycare, or that their daycare provider is closed. So this is a child care provision. The children do not have to be sick with a serious medical condition in this category. So an employee who's been employed with an employer for 30 days can take 12 weeks off to take care of their child who's home from school or a daycare center that's been closed due to the pandemic. The first 10 days of this expanded FMLA category is unpaid. The next 10 weeks are paid at 2/3 the employee's regular rate, capped at $200 a day. And over the next 10 weeks, that's $10,000 in the aggregate. So there is a cap, and the first 2 weeks are unpaid. Next slide. So we thought, oh, okay, the first 2 weeks are unpaid. That's a little bit of control on this, but no. In the same legislation, the Emergency Paid Sick Leave Act grants all employees 80 hours of paid sick leave. These two laws go into effect on April 1st. So what is this new 80 hours of paid sick leave? It is just what it is. Like most people have paid time off policies where they're granted vacation or sick leave, and that's defined in your handbook. Well, on top of that, the federal government is ordering employers with fewer than 500 employees to grant employees an additional bank of time on top of what they have already accrued. And this is the emergency paid sick leave. And you can take this 80 hours for one of 6 reasons. One, if the individual is subject to a federal, state, or local quarantine isolation order related to COVID-19. 2, the second reason is, has been advised by a healthcare provider to self-quarantine related to COVID-19. Or 3, is experiencing COVID-19 symptoms and seeking a medical diagnosis. Let's pause here on these first 3 categories. The rate of pay that an employer is required to pay out for one of these 3 reasons is the employee's regular rate of pay capped at $511 or $5,110 in the aggregate. In the next three reasons, the rate of pay is capped at $200 a day or $2,000. And let's talk about the next three reasons. If the employee is experiencing COVID, or the next three is number 4, if the employee is caring for an individual subject to an order of self-quarantine or isolation, federal, state, or local. The 5th reason that an employee can take this 80-hour allotment is if they're caring for his or her child whose school or place of care is closed due to the COVID-related reasons. And the 6th reason is a pretty big catch-all. But if the employee is experiencing any other substantially similar condition specified by Health and Human Services. That's a pretty big catch-all, and we don't know what Health and Human Services is going to define as a substantially similar, but those regulations are being written now. So practically, how do these two laws work? They are separate. To help you think of these two laws, please remember these are two separate and different laws, but they overlap each other. So employers with fewer than 500 employees on April 1st have to comply with both laws, the new expanded FMLA and this 80-hour sick leave. So how do they work and overlap each other? So we talked about 12 weeks of expanded FMLA for people who have to take care of their children because their schools or daycares closed due to the COVID. The first 10 weeks are unpaid. So the HR managers are thinking, okay, it's unpaid, but then wait a second, the employee usually can elect to take their accrued PTO, vacation, or sick time, or now the employee can elect to take this bank of 80 hours in order to get paid. If they're taking it to take care of their children, that is reason number 5, and it's paid at a maximum of $200 a day, capped at $2,000 over the 2 weeks. Then, for the rest of the 10 weeks, the employee can take the expanded FMLA paid leave. The employers cannot force an employee to take one type of paid leave over the other. This is an election entirely at the discretion of the employee. So we can count on the employees trying to figure out which type of leave they will get paid more on, and they'll probably take that. So, or they might want to save their vacation time and sick leave for something in the future and avail themselves of this new 80 hours of paid sick leave mandated by the federal government. Next slide. So we think right now the effective date is April 1st, 2020. And I'm getting a lot of questions about how these laws work, combined with when are they eligible for unemployment, what do we do about health insurance, how do the tax credits work, and then with the state of Ohio's recent stay-at-home order except for essential businesses, there's a lot of questions of how employers are managing their workforce, how are they going to pay for these new mandates, when do the tax credits kick in. One interesting question that I had was, okay, John, I'm allowed to stay open because I'm an essential business. but my employees aren't coming into work because they're scared to come into work. What do I do? In the end, so you have to ask a couple follow-up questions of the employee. Employee, are you diagnosed with a COVID-19 diagnosis? No, I'm not. Okay. Well, are you caring for someone with a COVID-19 sickness? No, I'm not. Okay. Do you have any symptoms? No, but I'm just scared to come into work because I can't afford to get this virus. Well, then the employers have to think, well, can you telework? Or is this a job that doesn't avail themselves of telework? And I really need you to come in to operate this press that's churning out product for hospitals or military defense or other essential businesses that need the product. And you have to be in here to run this machine or to do this type of work. If the individual is not symptomatic, not diagnosed, and they're just staying home out of an abundance of caution, I think you as the employer have the right to ask them and to come into work. That their absence is not a protected leave, and they're jeopardizing employment. On the other hand, if the person is diagnosed with COVID, has symptoms of COVID, or is caring for someone with symptoms of COVID or a diagnosis, then the analysis changes and you might have to grant them leave. But these are it's a very complicated set of checkdowns that you have to go through. Next, how do the tax credits work? Any expenses paid by the employer for these new leave laws, the expanded FMLA for child care, or the paid sick leave, 80 hours of paid sick leave, and even certain health care expenses, including health care insurance premiums, are eligible for a tax credit. The tax credit is 100% refundable tax credit against your employment taxes, the FICA. And any amounts in excess of what you have reserved for FICA are considered an overpayment and refundable by the IRS. So that's a little bit of good news. Some of my clients are saying, well, John, when can I avail myself of these tax credits? Because if I'm keeping the employees on and paying out this cash, do I have to wait for the quarterly tax returns to claw that money back from the FICA taxes that I deposited? And today I saw some guidance saying that you might not have to wait until your quarterly tax returns, that you may be able to avail yourself immediately as soon as you deposit that money into your FICA tax account, you may be able to claw it back. So that's a little more good news. So keep your eyes and talk to your accountants about how soon can I get that money back, because that might help. And lastly, there might be some more good news about these SBA loans. The Senate drafted and passed legislation 96-0. It's going to the House, and small businesses through the SBA loan process may be eligible for loans up to $10 million based upon payroll, rent, blah, 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 which may be forgivable at the end of the loan. The information coming out is as soon as next week, these loans, the SBA loan process, you should be able to walk into your FDIC approved bank, apply for the loan, and have the loan approved that very day. That's the type of timeline and expedited loan process to get the cash into your small business that is coming. So keep your eyes open for the SBA loan process and start pulling together your documents in order to qualify for that SBA loan. A lot of clients are looking at their cash flow and trying to figure out how can they afford to stay open with these new employment laws, tax credits, SBA loans, and their orders drying up. So the faster you can avail yourself of the tax credits and the SBA loan, that might help you get through it. And especially if this loan ends up being forgivable, that might be an incentive to employers to keep their employees on longer than as opposed to the having to immediately lay them off. So those are my comments for the presentation. Let me know if you have any questions.
Thank you, John. There are a few questions in the chat box. One thing I did want to point out to those that are on the call right now is that Manufacturing Works is already trying to line up some experts that will be able to address whatever this legislation looks like once it passes through the House, so that anybody in our wheelhouse will have this education and have the opportunity to ask questions from the experts. But for right now, let's go to the questions that we have in the chat box. Number one, we have from Ann Brosnan. It says, is there specific guidelines to determine which symptoms are possible COVID-19? There is no testing at the beginning of illness, very hard to determine cold, seasonal allergies, flu, or COVID.
The specific guidelines are being written by the Department of Labor at this time, and they are expected to be out no later than April 1st. So the answer is, at this time, there are no guidelines, but we should know within the week.
Great, thank you. And then Brianna Schultz says, what if they are part of an at-risk demographic? Does this apply to full-time and part-time workers?
It does. It applies to full-time and part-time workers. And if the employee is part of a higher risk, I understand that. But again, when I get these questions, I ask, are you diagnosed with COVID-19? Yes or no. If you are, then stay home and stay home for 14 days. If you are not diagnosed, are you symptomatic? If you are symptomatic, then yes, stay home. If you're not, then, if you're not diagnosed or symptomatic, then I think you should be coming to work.
John, this is Fred, and I can add just a portion to that. Absent the at-risk demographic being identified by this law and having anything specifically apply to it, under current law in Ohio, under workers' compensation law, the only way that an employee is going to have a potential claim against its employer is for an intentional tort. And under Ohio law, that's going to be a deliberate intent to injure, which in my assessment of COVID-19 and the at-risk demographic, I don't think you're reaching that level of an intentional tort, if that helps, Brianna. Thanks, John.
Yep.
Thank you. And then there's also a question here from Robert Guy that says, what kind of documentation can an employer require from an employee to prove it is one of the 6 covered reasons? Also, can you fire someone who is abusing the system or falsifies documentation?
If they say they're this is an excellent question, because there is a general trend in this emergency to just take the employee's word for it. That is the general trend, that most people are saying, don't ask for documentation, and we just have to trust their word.
Don't ask.
But if they say they're diagnosed with it and you suspect them, yeah, I think you can ask for the medical diagnosis. If they say, well, no, I have to stay home because I've been advised by a healthcare provider to self-quarantine, they're going to say, if you say, well, show me that diagnosis, they're going to say, well, I talked to the doctor and it was all over the telephone. So they're going to wiggle out of it that way. And you're going to ask, well, do I have to take that? You're probably going to have to take it. But you can ask, hey, if they wrote you out an order to, if the healthcare provider wrote you out an order to stay home, you can ask for it. But I think you're not going to get it in most cases because the healthcare system is so busy. And can you discipline someone if they are engaging in fraud? If they say, well, I've got to stay home and take care of my children, but you find out that they're not really taking care of their children because on Facebook they're going out fishing or they're going out golfing, and yeah, I think you can discipline them for fraud. But again, you're gonna have to have rock solid proof that it is fraudulent, because what is that? The benefit of the doubt is going to go to the employee during this crisis.
Okay. There's a question out here. It says, can you provide the general factors considered in the calculation of the tax credits you can claim, i.e. Payroll?
The factors are, and this is going to, the HR is going to have to track the expanded FMLA and the emergency paid sick leave. But the factors eligible for the tax credit are any monies paid out under the expanded FMLA for childcare for this 12 weeks, and the emergency paid sick leave paid out for reasons related to the COVID-19. So that's that 80-hour bank of time. And any monies paid out for individuals taking paid FMLA for childcare reasons due to a school closure or daycare closure. The other expenses include certain healthcare expenses related to the COVID-19. So there was talk about the testing, if your healthcare plans incur any other expenses. But I would also add in, if you keep your employees on from April 1st through this, I would certainly ask for a credit of the healthcare premiums, the employer side premiums that you pay as part of that credit. So right now, a lot of my employers are doing that calculation of, gosh, do I keep the employees? Can I afford to keep employees employed and their healthcare costs for the next month or two? And I think the federal government is trying to give you some incentive to keep employees employed and keep their health insurance during the next month or two. And that's why they're offering this tax credit.
Okay. Looks like, oh, someone is also asking if you could please quickly review the 6 situations for the extended paid sick leave.
Yes.
Thank you.
Reason 1, if the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. 2, if the employee has been advised by a healthcare provider to self-quarantine related to COVID-19. 3, if the employee is experiencing COVID-19 symptoms and seeking treatment. Number 4, if the employee is caring for an individual subject to an order described in reason number 1, meaning if the employee is caring for an individual subject to a federal, state, or local quarantine order, or someone who has been ordered by a physician to self-quarantine. Number 5, if the employee is caring for his or her child whose school or place of daycare is closed due to COVID-19 related reasons. And number 6, if the employee is experiencing any other substantially similar conditions specified by the Health and Human Services Secretary.
Thank you. The same person that asked that question just messaged and says, we are essential. An employee has already stayed home for 2 weeks to care for children. Any help for them?
Any help for the employee or for the employer? So I'll answer both questions.
Employee, it says.
Is there any help for the employee who's already stayed home 2 weeks to care for a child? I've got bad news for employers, good news for the employee. The good news for the employee is that on April 1st, that employee is going to get another 80 hours of sick leave granted, because this new 80 hours of paid sick leave goes into effect on April 1st. So I don't know that if that employee has stayed home, I don't know how the employer has treated them. Has the employer made that employee take vacation or sick leave? But my point is, on April 1st, they're going to get a brand new 80 hours. Is there any hope? Yes. They get expanded FMLA. So they will get paid FMLA for 10 to 12 weeks. And the employer gets to take that tax credit. And again, that tax credit is 100% refundable. It's an offset against your FICA taxes that the employer has already deposited into your payroll account. So you can just claw that money right back.
Okay, and then there's a question here. It says, what happens if business is essential, but employees refuse to return for safety reasons? All I've heard was that they are not protected leave. What does that mean?
Yeah, I mean, it's if you are an essential business and you have an employee that you need to show up at work, I think the employer should treat it as it would any regular employee, and start your discipline process. Why aren't you showing up for work? Then we are gonna discipline you. And if you end up terminating that employee, who is staying home out of an abundance of caution, they are not eligible for unemployment. Again, we're assuming that this employee does not have COVID. He's not been diagnosed. This employee does not have symptoms of COVID. And this employee is not taking care of a family member who has COVID, and they're not taking care of their child who's home from school. If they are just, and there are employees who don't fit into any of those categories who are afraid to come into work. Well, employers are taking their workplace safety extremely serious these days. They are cleaning it. And so the employers are providing a safe workplace. And still an essential employee is staying home out of an abundance of caution, well, then you can start your traditional discipline process.
Okay. And then I just lastly here, one last thing, and it's just a comment. It says all expenses related to these new paid leaves are refunded through FICA or some other means, correct?
It's through FICA,
Yeah.
through FICA offset, and anything in excess of the monies you've deposited into FICA on your quarterly is deemed an overpayment and is refundable. So you can apply for a refund from the U.S. Treasury.
Great.
But that's limited to expanded FMLA costs, emergency paid sick leave costs, and certain healthcare costs, including group health plan insurance premiums.
Okay. It's okay. One last question, and then we've got to go ahead and wrap it up to be respectful of time. And it says, what about the pay for 80 hours and the 10 weeks of FMLA?
What about it's yes, yes. You have to pay 80 hours and 10 weeks of FMLA.
And then
you have to pay both.
And then
if the employee takes it.
Right. And then you get that back through your FICA.
Yes.
The credits. Okay. Terrific. As you can see on the screen in front of you, the contact information for all of our presenters are here. So feel free to copy down their information and reach out. I know they would all be happy to help in any way that they can. And I just want to thank everyone for joining us on the call today. And thanks to our experts for sharing such valuable information and insight during these trying times. We encourage all of you to share with us your thoughts on topics that you'd like to see covered in future calls, and we will do our best to address these for you. Please stay tuned to your email as we announce our next call. And if there are other manufacturers in your network that you think would benefit from this information, feel free to share this with them and let us know, and we'd be happy to reach out to them as well. And remember that this call will be archived in our YouTube channel, and the link to our YouTube channel can be found on our website. Thanks again, stay safe, and we look forward to speaking with you all again soon. Goodbye, everyone.